Hi, so for those of you who don't know me, I'm attorney Brittany Paz. I practice almost exclusively criminal defense. I'm going on my 7th year now. And I was talking to a colleague of mine a few weeks ago, basically saying that I should record my after court rants. And the reason is because stupid stuff happens in court every single day, and not just stupid stuff like it boggles the mind that it's so irrational, but also unjust things happen in court, despite how much you may try to object and or fight it. Sometimes there is no fighting it. So in today is one such example, and I want to just basically explain what happened so that y'all understand that if you find yourself in this position, it's not because your lawyer is not fighting for you, it's because the system is literally set up for you to fail. So I have a client who is on probation, and he is stopped in connection with a drug investigation, but the stop is completely devoid of reasonable suspicion. So in other words, the police had no suspicion to stop him. However, they saw him near a person who they did have reasonable suspicion to stop, and so they stopped and searched him as well. And when they search him, they find some marijuana, which he has a marijuana card for, and they search his phone and they see some text messages which they say contains narcotics lingo. Obviously, the marijuana that they seize and the narcotics lingo that they see would normally be the subject of a nice motion to suppress. However, my client is on probation. And what does that mean? Well, I'll tell you what that means. That means that they threaten and cajole you, basically, to say, if you don't want to plead guilty to the offenses which I say you have to plead guilty to, I'm going to put your violation of probation down for an immediate hearing, at which point you would then be subject to basically a hearing where you almost have zero chance of winning because it's a lower burden of proof, and for which I also cannot suppress the evidence because there's really bad case law that suggests that you have no rights on probation, so it doesn't matter if your rights were violated with the stop, they could still basically put that evidence against you at a violation of probation hearing. So basically, even though the state attorney has no reason for the stop, can't even articulate a reason for the stop, they're in a position where they don't care. They're offering jail time because my client is on probation. So they're like, well, I don't care that your client's rights were violated, he was on probation. So I get up and I scream and hem and haw about how unjust it is, and the judge just says, sorry, there's nothing I could do about it. I can't force the state to drop the charges. The best thing I could do for your client is make him an offer that he probably can accept. So for you clients out there who are on probation, know that your rights may very well be violated in connection with a new case. However, the system is set up where you have no rights on probation, and they will use that probation status against you to coerce you into pleading guilty to things that are not necessarily that there really isn't evidence for, or enough evidence to support, simply because they know you don't want to go to jail and you will do anything to minimize whatever jail exposure you have. So this is my rant for the day. If you have any questions about further unjust events that happen on a daily basis at court, feel free to email me. It's Brady@RuineAttorneys.com, or you can call me and we can have a chat. My phone number is on the website. Thank you.